Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be tenants should be forced to post rent money with the court. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. We all know the ground rules, which is that I have an opening topic. And then I will open it up to questions and answers. If you are in the Zoom room, as opposed to YouTube Live, then please electronically raise your hand. You can do that right now, so you'll have the best chance that I will get to your question. Well, the song, in honor of Valentine's Day, I figured I'd play one of the best love songs that I believe to be, and that was the song called Hello. It was by Lionel Richie, and it also featured Jennifer Nettles. It was released in 2012, and it became one of the best-selling albums on the Billboard 200. So now, we're opening it up to that topic. And what is the topic today? Well, the topic is tenants should be forced to post rent with the court. Tenants should be forced to post rent with the court. Now, why did I choose this topic? Well, when a tenant fails to pay the rent, the degree of difficulty to prosecute a non-payment of rent case is literally off the charts. Now, if you have a general contract dispute with another person, it's pretty damn simple. All you got to do is send them a note or call them and say, hey, I want you to pay me. You violated the terms of the contract, please pay me. And if he doesn't, you have the right to bring forth an immediate legal action, a contract dispute, a legal action to enforce your contract rights. But that's not what goes on for landlords who are merely trying to enforce their basic rights to collect rent, their basic right to collect rent. There are numerous rules and regulations imposed by landlords, both on a state level and local municipalities. These laws are insane. For example, on a notice to pay rent or quit, you have to have specific language in your notice. If you don't have the specific language in your notice, you will lose your case. They also have specific rules on how you serve the notice. If you don't serve the notice correctly, again, you're going to lose your case. These are all prerequisites to filing an unlawful detainer and eviction lawsuit. Now, some jurisdictions really make it difficult. They state that you can't even start an eviction case unless you register the unit with that local municipality. Also, some of these local jurisdictions require that within 3 to 5 days that you send a copy of that termination notice, the notice to pay rent or quit, to them, to the city rent control board. If you don't, again, you lose your case. Some local jurisdictions say, well, you can't even serve a 3-day notice unless it's above the minimum standard, which is based on the fair market value as published by the HUD, Housing Urban Development. Some jurisdictions require that when you serve a properly filled out 3-day notice, that you have to have other forms included with that notice. And again, there's also requirements that some jurisdictions require that you post notices on a conspicuous spot on your property. You don't do that, you've lost your case. The landmines that exist for a landlord merely to try to get his damn rent is insane, ladies and gentlemen. Literally, the skill level to prosecute a simple unlawful detainer is absurd. The protections afforded to tenants have created a system where tenants can easily avoid their obligation to pay rent. Now, let's pretend you've done everything correctly. You've registered your units, you used a proper notice, you served it, you had all the forms posted, you did everything that that state requires of California and the local municipality where your property is located. And then, ladies and gentlemen, you get to file a proper eviction lawsuit, which is called an unlawful detainer. every time, with few exceptions, that you file an unlawful detainer based on non-payment of rent, the tenant will try to defend the lawsuit based on this theory called the doctrine of habitability. So what is this doctrine of habitability? It states that if there's a substantial issue with regard to your property affecting the habitability, and that's a substantial issue, then the tenant has to inform the landlord unless the landlord should otherwise reasonably know. And if the tenant does inform the landlord and the landlord doesn't, within a reasonable period of time, correct the situation, this doctrine of habitability states that the tenant legitimately can withhold rent to force the landlord to make the repair. That's what this doctrine of habitability is all about. Again, the landlord has to know about the problem either because it's self-evident or the tenant specifically told him. The tenant gave the landlord a reasonable opportunity to fix the problem. The landlord refused, and now the tenant, under the law, has the right to withhold rent. Well, this doctrine of habitability has been abused by every single tenant with almost without exception. And usually what happens in these cases is that the landlord is never informed that there's a problem with the case. The only time the landlord knows there's a problem with the case is when he reads the tenant's answer in the unlawful detainer. And I tell you, I have clients who are calling me time and time again and saying, oh my God, this is not true. He's never told me this, but this is what happens with almost without exception in every single case. And then this laundry list that the tenants put into their answer as to the reason why they were withholding rent, either they weren't told to the landlord, or more likely, these conditions don't even exist. Or if they do exist, it was based on the intentional damage caused by the tenant in order to bolster his case. So in that situation, a landlord is forced, during the middle of a lawsuit, we recommend that they hire a contractor to go in there and to inspect the damage. And when you hire that contractor, sometimes the tenants won't even let you in to check after proper notice. But if the contractor does get in, he can determine, number one, do these conditions really exist? And number two, was it caused by negligent or intentional damage by the tenant? So if in fact it is legitimate, at that point in time, I always advise my clients take care of it immediately, even though this is your first notice of a problem, even though we're in the middle of an eviction lawsuit, take care of that immediately. Now, this becomes an uphill battle for landlords. Judges routinely approve habitability defenses, even on minor issues. And this forces the landlord to settle the case where they're foregoing all the rent owed just to get the tenant out. And of course, this allows the tenant to do it to the next landlord and the next landlord. And remember that eviction cases, based on our wonderful state legislators, are sealed, which means that you as a landlord trying to judge an applicant can't find that this tenant was evicted because his record is sealed. And that's why I recommend, if you're dealing with applicants, that they, as part of the application process, that you make them prove that they paid their last 3 months rent to their current landlord. You want to see that proof. If they can't produce that proof, guess what, ladies and gentlemen? It means they didn't pay their landlord. It means they probably got evicted. Also, your rental agreement should contain a provision that states all repair requests, except for emergencies, must be in writing. This way, when the tenant comes to court with this laundry list of items, you can easily show that you never got any kind of a writing. So on that basis, it's a much easier case. Now, I want to show you guys a typical answer, and I grabbed this from my one of my cases. So this is a true answer. I'm going to share the screen right now and make this bigger. So let me share this screen, and I want to show you this. I think you'll find it amusing. Okay, so this is a typical answer It's that second page of the answer where they get this form from the court and the tenant just merely has to check off the boxes. So let's take a look what this particular tenant, this is one I just grabbed from one of my cases today. He's claiming that there's damp, leaking ceilings or walls, falling plaster, defective, inadequate gas services. God only knows what that means. Missing or broken windows or doors, torn screens, holes in the carpet, defective plumbing. It just goes on and on. Infestation of roaches. Uh, Common areas are unclean, inadequate security locks, and then the best one, ladies and gentlemen, where it says other, right over here, ladies and gentlemen, landlord sent an individual to graffiti the front door in my unit with the large letter A. I can only imagine what the A stands for. So you can see what I'm talking about, and I'm going to stop sharing the screen here, is that the landlords are facing this uphill battle to have to prove that, in fact, these conditions don't exist or that they were never told about it. So, quite frankly, the system needs to be changed. And there's such an easy solution. And the easy solution is that when somebody claims habitability, they first have to post the rent with the court. Now, if the tenant truly is withholding rent because he begged the landlord to make the repairs and the landlord callously refused, so he withheld the rent, well, then that would indicate that he has the rent. And why shouldn't he post that with the court? And if he can't post that with the court, then he shouldn't have the right to use the defense of habitability. It's a simple plan because, quite frankly, the truth is that this is just a total abuse by tenants in every single eviction case. The truth, the tenant doesn't have the rent to pay. And that's why he goes around looking for things that he can complain about without ever telling that to the landlord and just including that in his answer. And I don't care that the reason that the tenant didn't pay the rent because he chose to go on vacation as opposed to paying the landlord, or conversely, that the tenant lost his job and truly can't pay the rent. I don't really care. This is not the landlord's responsibility to take in another family member and support them. That's either the job of charitable organizations or maybe our state, okay? But that shouldn't be our job to take care of this. So in that situation, we need to have the law changed. And the law, again, would state that if you want to use the defense of habitability on a non-payment of rent case, you have to merely post the rent with the court. The rent that you are, quote, withholding because of the conditions that the landlord callously refused. Now, how do we get the law to change? Well, we need to start advising our state assembly members and our state senators that this law needs to be instituted. And there's a really simple way to do it. The first thing is you need to find who's your state assembly member or who's your state senator, and that's easy. You go to a website. This will be in the show notes, ladies and gentlemen, and the website is findyourrep.legislator.ca.gov. Once again, findyourrep.legislature.ca.gov. You're going to go to that website. You're going to put in your zip code. You're going to be able to easily determine who your state assembly member is, and you're going to be easily able to determine who your state senator is. And one of the options there is to email your state legislature or your state legislature, either the assembly members or your senators. And then you can tell them what you want. Now, I'm going to have this in the show notes too. This is what I submitted to both of my state legislators today. And I'm going to read this to you, but it will be in the show notes. You could just copy it and send it to them. This should take no more than 4 minutes for you to address this to both of your state legislators. So here's what I wrote. For unlawful detainer actions, I would like legislation passed that tenants must post their rent money with the court to avail themselves of the defense of habitability. This defense is typically abused by tenants who allege faulty conditions with the premises which do not exist. In other cases, those conditions have never been reported to the landlord. A tenant who claims to be withholding rent due to the condition of the premises clearly should have the rent and therefore can easily post it with the court. This proposed legislation will prevent fraudulent claims by tenants who are merely attempting to game the system. Please, I encourage you to send this to your state legislators so that we can get this law changed. This is a law that is truly a fair law and would be one small piece of favorable legislation for income property owners, those people who give housing services a necessary industry for the state of California. And that, ladies and gentlemen, concludes my opening topic. We're now going to open it up to questions and answers. And we know the rules. Of course we do. And those rules are that this broadcast is for informational purposes only. It's not a substitute for legal advice. If you want to talk to me, please electronically raise your hand if you're in the Zoom room. And if you have an existing case with me, thank you very much. But we do not talk about specific cases. We only talk about general questions. So please pose it in that way. And last but not least, don't be shy. If you have a camera, it makes it much more enjoyable for the audience if we can each see each other. And with that, we're going to open it up to our members who want to talk to me. And the first one is an old favorite. You're not old, but you're an old favorite. And that is Jim Polina. Say hello.
Hey, you know what, Dennis? Whenever you say ladies and gentlemen, you remind me of the famous Chick Hearn. You sound just like him.
Well, you know something, I watched a lot of Chick with my
Yeah,
love
so did I.
of
Yeah,
the Lakers.
good times. Okay, I got two unrelated questions. One is if I'm selling a house simultaneously evicting a tenant and I sell the house, can the new owner step into my place without restarting the eviction?
Okay, if the reason was for fault, that is the tenant wasn't paying the
Paying
rent,
rent.
started the case, and then magically escrow closed, can the new owner just take up where you are? And the answer is yes. And we do it in a very simple way where we don't even have to change anything with the court. And what we do is we have the new owner send a letter to the old owner, that would be you, Jim, and it states, I hereby appoint Jim Polina as property supervisor to continue to manage my property with permission to continue on with any unlawful detainer actions. So with that appointing you as the property manager, you haven't lost control of the building, and with your permission, you can proceed forward to continue on with that eviction.
Good to know. Okay, question two. When I finish my ADU with the house that is exempt from AB 1482, what happens to that exemption to the house?
Well, your house is exempt, but once there are two units on one property, then assuming that house was built more than 15 years ago, which I presume it is, then that immediately becomes under statewide rent control, AB 1482.
Immediately.
Immediately upon receipt of the certificate of occupancy for the ADU, that would be the accessory dwelling unit. For the ladies and gentlemen out there, it's that Jim is building an additional small unit on the property. But by building that small unit, now you lose your exemption because now there's not just a single family residence. But the unit, the ADU, is exempt because that's new construction built within the last 15 years, but the house now is under. So make sure that before you get that certificate of occupancy, make sure that number one, you like the tenant, because otherwise you could get rid of them, and make sure that your rents are at market value, because as soon as you get that certificate of occupancy, you're limited in terms of your rent increases.
Thank you very much.
You take care, sir. We are moving on to Noel Diaz. Say hello.
Hi,
Hello.
hi, Dennis. How's it going?
Good.
Thank you for everything you do. And I have two questions. I have a RSO unit in the city of LA, and I will do a 60-day owner occupy. I'm planning to deliver this tomorrow. I already paid the fees with the LHD. Um, my question is in regards to the dates. I know that, today you were in a weekend, and also there's President's Day. Um, And I know there's a few days that I have to give them. Like I think you said if I mail it out. But I just want to know what are the dates that I should include as part of the notice.
Okay, well, first of all, that does not apply to a notice to quit, a 60-day notice to quit. And again, for the audience, you want to move into your own unit, so you have filed the proper paperwork with the Los Angeles Housing Department. Now you have the right to serve a 60-day notice on the tenant. You are going to have 15 days from the service of that notice to pay the relocation. But in terms of what dates are excluded, the answer is there are no dates excluded. So the day you serve the notice is day zero. 60 days the tenant has from that, including Saturdays, Sundays, holidays. And then on the 61st day, if the tenant is still there, then you have the right to bring forth an eviction.
Okay, got it.
And one other thing that you need to be careful about is do not take any rent past the expiration of the 60-day notice. So for example, let's pretend that notice expires as of May 25th. But on May 1st, you took all the rent for the month of May. If you do that, you've already ruined your 60-day notice.
Okay, and if he sends me a Zelle, I should just return the difference because it's going to be not within the
Yeah, if he
with
does sell it, you can return the difference and add an extra day just to be on the safe side. So he gets an extra day's worth of rent. But yeah, return the difference. If he gives you a check, do not cash it. Return the whole check to him
Okay,
because you can't take any rent past the expiration of the notice.
okay, great, thank you. And
All
then
right, thank
my second question, sorry, is with the owner occupied, my understanding is that the unit will be under rent control still. So if I decide to move out in 2 years, I would have to put it back to the original rent plus any additional rent increases. However, I'm looking to do like an addition, so adding an additional room, an office, and so it's going to change the complete characteristic of the unit. It might still require to put it back to whatever rent it was.
And the answer is yes. Adding on to the house is not going to help. If you like demolish the place and there was a brand new, entirely new unit, that would be a different story.
Okay, got it. Thank you.
Okay, we're moving on to Arlene. How are you this Saturday?
I'm good, Dennis. How are you?
I am
I wanted to
fine.
give you an update. I had talked to you last week about JCO and that they said I didn't have a statement number and that they were going to be sending out to everybody in the county in March. I emailed them and they actually got back to me with a bill. So I was able to pay with the statement number and the APN. So I was actually able to pay it. So if anybody wants to do that early, my suggestion is to try to email them, LAHD.
Yeah,
They
the
did get back.
problem is it's supposed to be paid by February 28th. That's what the law states. But of
Right.
course, LAHD, the Los Angeles Housing Department, doesn't have their act together. I do want to compliment you on your very festive sweater that you're wearing for Valentine's Day.
Oh, yes. Thank you. I have about four quick yes or no questions I have for you. Can you put an addendum on a lease to accept notices via email? Like your 24-hour notice, can you do it or do you still have to go post?
I think if the tenant agrees to that, I think you're okay. I don't know any law that says you can't.
Okay. And I know we had talked about people now, when you're taking a security deposit, that certified checks are not always good, that you should wait for them to clear before you give them the check. Can you safely, if you receive it through electronic transfer, are those considered safe or can those?
Once it clears, it clears. So if it's in your account, then it's in your account.
Okay.
A wire transfer or like a Zelle, once it's in your account, you're safe.
Okay. And you were talking about seeing the notes from the show. Where is that on YouTube or it's not on
Yeah, you go to
camera?
YouTube and you'll see I'm going to be editing this, and I'll put all those frames up so you can actually see it on the screen, but it'll also be in the notes on the YouTube edited version once I do it, which is usually I get it done within a couple of hours of showtime. So while you guys are going about your business, when I end this show, the first thing I do is I edit this broadcast and put in a lot of cute pictures and statements and all the information.
Okay, and two quick things. You say that all of the repairs have to be in writing. Does the text count, or it has to be
No, a
like
text would be fine for repair requests, that they can be text, they can be in writing, they can be in email, however they get it to you is fine, but there is a requirement so that this way we can establish in court that, hey, he never told us about this.
Okay, and for the last 3 months payment, I'm trying to rent to somebody who lost their home in the Palisades. They were homeowners, but they don't have a mortgage anymore. So just,
Yeah, well, if they're not, we only want to make sure that they didn't fail to pay their landlord their rent. So, but if they were homeowners, for example, then they never paid rent, so we don't have to worry about that.
okay, great. Thank you so much. I appreciate it. Have a great day.
Same to you. Thank you so much. Austin, how are you today?
Very good, Dennis. Can you hear me okay?
I can, but you're kind of sideways. I'm getting dizzy.
Oh, I'm sorry. Let me fix that.
Now, much better.
Okay, there we go. All right, so I've got a fun one. So I am owner occupying a fourplex in the city of Long Beach, and this municipality allows for substantial remodel evictions. You pay the tenant $4,500. You go through the city and you get a permit for like plumbing or electrical. As long as you have enough renovations that will render the property useless for at least 30 days. So my question is, the unit that I want to do this on, the tenants are significantly below market rent, but the unit is in good condition. Anybody that would take a walkthrough would say, yeah, this doesn't need to be remodeled, but as you can see, I want to use this as a tool. So if a tenant contests this and they say, well, Your Honor, this unit did not need to be remodeled, the landlord's just remodeling to get us out of here, what's the judge going to say?
There is a provision in most rent stabilization ordinance that state that the eviction has to be for a good cause. And if in fact you really are just trying to game the system, so to speak, by renovating a unit that was maybe just renovated, then I would think that the court would find that you're in bad faith. So you have to have good faith in order to bring forth these, and it's always in every statute. So I think you'd have a problem with that. So maybe if you could add in, for example, another bathroom, for example, and also then do some work with the kitchen, that might get you past that test. But if the unit, looks great and now you're just renovating it to renovating it, then you have a problem. But I would guess though, Austin, that the rents, if it was recently renovated, that the rents should be to market value, is it not?
Not even close.
Hmm.
They're paying about 1,500 for a 2-bed, 1 bath. The market rent in this area is closer to 1,900, 2,000.
What you might want to do is
So,
tell the tenant that you're planning on renovating the unit and he's going to be given X amount security deposit and a 60-day notice to vacate, and this is in accordance with the law. And then tell him, however, if you agree to move voluntarily, I'll give you the relocation plus, and then you fill in the blank, an extra 5,000. He might bite on that, and you don't have to get into the bad faith claim that might crop up in a court of law.
yeah, no, that makes sense because I would most certainly offer the tenant more money to leave voluntarily because then I wouldn't have to do any
Yeah,
renovations, or if I did do a renovation, I wouldn't have to use permitted contractor, licensed contractors with permits and everything. Okay, thank you.
good question. We are moving on to my friend Sam. How are you?
Hi. Hi. Yeah, thank you. Sorry. Thanks, Dennis. So I have a question piggybacking off of what you already addressed in your opening comments. How about these folks that are what I call predatory squatters who move around from one place to the next based upon and don't pay rent once they move in, based upon the confidentiality of the unlawful detainer filing? Is there some way for landlords, property owners to put in a database, hey, I filed a UD against this person, even though it's not in the public records, not in the court records. You can't search it. Here it is. Here's the PDF, or at least the case number and who it's against and what
You
the
can
rent owes.
you
Yeah.
can certainly do that. Many of the apartment associations have
Yeah.
provisions for doing that. You can also report to the credit institutions directly. They're now forcing under California law to for landlords, if the tenant requests it, that they have to report positive rent payments. Well, you can certainly report negative rent payments as well. So definitely that can be done. There's nothing, the fact that the unlawful detainer action is masked, is sealed by the court, doesn't prevent you from walking on, Hollywood Boulevard with a sign saying, I evicted this person. Nothing prevents you from doing that.
As
So
long as it's
certainly,
truthful. As long as it's
yeah, as
truthful,
long
I
as it's
think.
truth.
Yeah.
The truth is a great defense.
And then last question, piggybacking off my just question I just asked now. How does an individual homeowner who's looking to rent to a roommate, how do they protect against serial squatters or what I call predatory squatting? Other than, I mean, they
Well, you
typically would not have access to AOA and because they're not an AOA
well, you
member.
can
So,
you can always run a credit check on somebody, even if you're not a member of an apartment owner association, which I highly recommend that you do.
yeah.
But you can always run a credit check, and then nothing prevents you from doing a civil lawsuit check to see if the guy's been involved in not just an eviction, but he's been involved in other lawsuits. If you find out by going to the, let's say, for example, Los Angeles Superior Court and checking the plaintiff defendant index, and let's pretend this guy has been sued 16 times by different people, or conversely, you see he's brought lawsuits against his own landlord. This is a person that you wouldn't want to take in. Also, again, the trick is to ask him for proof of payments the last 3 months or 6 months to his previous landlord. Let's see if he's been paying them. That's a way to stop this, ladies and gentlemen, because if you get bit, and I've said this before, by the time you pay your good-looking attorney his fees and the lost rent, the time waiting for the sheriff to finally do the lockout and then to rehab the unit, you're looking at over $20,000 because you made a poor decision based on somebody who had no intention. So again, you must be diligent, ladies and gentlemen. I know you want to rent out these units, but I can't tell you that it is much, much better to have a vacant unit than have a tenant sitting in that unit not paying you rent. Thank you very much, Sam. We're going to move on to Bert. How are you, Bert? Bert, are you there? Asking to unmute yourself. Okay, Bert.
There we go. There we go. I was not able to do it. So thank you for the questions. And to follow up to Sam's and your discussion on the previous topic, you had mentioned on the LA Housing Department, you can also see if a 3-day notice was filed to the building. So I think you look at the 3 months rent and LA Housing Department, I think you can make up your mind. Um, in a previous podcast, you mentioned the question came up, do we need to have a month-to-month lease or a 1-year lease? And you mentioned, I believe, that if you have a property under RSO, you would go with a 1-year lease and not month-to-month. Why was that?
Well, because if your property is under RSO, then you can't just ask the tenant to move even 1 month or 2 months into the situation of the tenancy. So you might as well have the protection that he's liable for at least 1 year's worth of rent, because it's not like you can kick him out you'd have to have cause to kick them out. But for example, if your property is under statewide rent control, or is under, let's say, the just cause ordinance for the city of Los Angeles. In Los Angeles, if it's just cause, then you don't have to have a reason for the first 6 months. So if you just don't like the tenant, he's just getting on your nerves, but nothing that you could really evict them for, you have 6 months to make that decision. The same thing is true with statewide rent control, except you have 1 year to make that decision. So if your property's under RSO, go for a year's lease. If your property is not it's under JCO, the Just Cause Ordinance for Los Angeles, or statewide rent control, I would go month to month.
Okay, thank you, Dennis.
And Alika Graves, how are you?
Hi, thank you for taking my question.
I think you're a newbie, aren't you?
Yes, I am. First one asking a question today. I would like to ask you, I hope to purchase a fourplex and I hope to move into one of those apartments or vacant. If it has a vacancy, do I have to take that vacancy?
Yes, because it would be considered bad faith if there was let's say, if the vacancy is a two-bedroom, but there's an occupied two-bedroom, you certainly would be forced to take the vacant unit.
Okay.
Now, purchasing this in the city of Los Angeles, is that what you're intending?
No, sorry, I forgot to mention in Northern California.
Okay, so I don't know whether they have any rent control there, but again, if it would certainly be under statewide rent control if the property was over 15 years of age. So in that situation, if there's a vacancy, you're going to need to install that that you have to move into that unit. You can't displace a tenant.
Okay, what if there's no vacancy and I want to take one of those units, preferably the bigger unit? How do I?
That would not be a problem under statewide rent control. So you would have to pay relocation, and there is a 1 month's relocation. It's equal to 1 month's rent. And you'd serve a 60-day notice on the tenant who's presumably been there longer than 1 year and is currently on a month-to-month. So you'd serve a 60-day notice and you pay the 1 month's relocation.
Okay, can I ask the tenant to vacate? And how much time are they legally entitled?
If they've been there longer than 1 year, they're entitled to a 60-day notice.
In the case that they refuse to vacate, what are the steps that can I take for
Well,
that?
then you hire an eviction attorney, which I'd be happy to help,
Yeah.
but I don't do Northern California.
Okay,
But
so
if you go to the Apartment Owners Association, you go to their website, AOA USA, you can get referrals for attorneys in Northern California. And with that, we're going to move on. Thank you very much. We're going to move on to Tatiana. Ask you to unmute yourself. There you go. Say hello, Tatiana. Well, I think you're having a problem with your mic. So I am going to mute you and we're going to move on. If you can figure it out, I'll come back to you. We're going to go to Daniela Moskovitz. Say hello.
Hey, hi.
I am fine, thank you.
So I have a 4-unit City of Los Angeles RSO. I sent the tenant a 1-year lease renewal with an 4% increase in rent. That was done in January. This is for a March start date. And I got a call from the tenant saying that they're interested in purchasing a property and they may be in escrow in mid-March. I haven't received a 30-day notice. I don't know what their intention is. So my question is, do I wait until March 1st and do a holdover? And or do I send them a note now and say, what is your intention? How do we proceed from here?
Well, are you really interested in having these tenants vacate?
Yes.
Okay, well, that was definitive. So do not take rent for the month of March unless they sign the 1-year lease and return it to you. If they don't, then that is a ground for eviction that they refuse to sign a similar lease. But the trick is, don't take March's rent. So what we would do is on March 1st, since it hasn't been returned, we would serve them with a 3-day notice to perform or quit, giving them 3 days to sign that rental agreement and return it to you. And if they don't, we have the right to go forward with an eviction. It's not a very common eviction, but certainly ones we have done in the past.
Okay, great.
Take care. We are going to move on to Leslie Hope. I'm going to ask you to unmute yourself, and Tatiana, hopefully you'll get your mic going because I'm going to pick on you next. But hello, Leslie.
Hello, Dennis. My situation is I have a tenant. He and his girlfriend have been there about 5 years. So I raised the rent 4% the day before, for February, the day before the rent was due. He tells me that he sends me a text. He tells me that his girlfriend has been sick for several months, and the bathroom has mold, and that there's a leak. Okay, so next day I put a notice on the door, 24-hour notice, and I sent in my trusty contractor, and they determined that there was no mold, no leak. So, oh, and he said the leak was only at night. It wasn't during the day. Okay.
Well, that's because leaks have to sleep, right?
Right. Well, no, the leak was awake at night.
Oh, I see. He had insomnia.
Yes.
So it stayed up at night, then it finally fell asleep. That's a smart leak.
Yeah. So, but obviously there was no leak there. I've never had a mold complaint. In fact, I've had, I've been doing this for 37 years. I've only done one eviction in all that time. But
Well, that's no fun.
well, good old Rick Tuseta. But anyway, okay, so no mold, but they went in, and I'd already had sort of an issue with him before because he wanted the grout in the bathroom cleaned. And my guys they went in for something else, I think a plumbing issue. And they said, it's he needs to clean it. It's not
Right.
our problem. Yeah.
I'm in agreement. He does need to clean that. I'm glad you sent your contractor in. If he doesn't pay the rent with the increase, obviously you can proceed forward with an eviction.
Well, he did pay the rent, but and we have the certificate. I mean, obviously I sent in a mold, or my contractor sent in his mold expert and determined, tested the air and everything, determined there was no mold. But what I wanted to start doing is I want to start documenting, because I think this guy's going to be trouble.
Right. Well, I would send him a note saying that you mentioned these items. We immediately contacted this contractor, and here's the report that says that there was no issues.
Okay.
And send him that. So, and then keep that in your file. Anytime a tenant has any kind of a repair request, you want to acknowledge that in writing after the repair job has been completed and send that note back to him. You complained about the garbage disposal on Tuesday. I had it fixed on Thursday.
They
Thank you
did.
for keeping.
They did, and it turned out to be like a pebble in the garbage
Yeah, well,
disposal.
sure, because that's how
And I tried to bill them, I didn't send in a plumber because I figured, it was them. I sent in my handyman, and if I'd sent in my plumber, it would have been, $210. The handyman charged me $50. So I told them, $50. So far, they haven't paid it yet. So I'll include that too.
Yes, ma'am. One last question, Leslie. Who's that a picture of?
Oh, that's me, but that's many years ago.
Well,
I
you
don't
look
look
beautiful.
like that now here.
You look beautiful. And we are going to move on to, let's move back to Tatiana. Did you figure out how to unmute yourself, darling?
Yes. Can you hear me now?
Yes, I can.
Awesome.
We stuck in together there.
Thank you. I appreciate you coming back to me. My question is regarding something you stated in one of your previous Zoom meetings about registering your.
Uh-oh. Oh, we got a bad internet connection. You're problematic today, darling. Yes, you got a bad internet connection. So If you got a question, you
No,
can, hi.
no.
Say something
Can you
again,
hear me?
please.
Testing.
Yes, go ahead quickly with your question.
My property's in Kern County. Do I need to register it as well, like if it was in Los Angeles County?
No, Kern doesn't have any formal rent control like they do in the Gestapo areas of LA County. So, but they do have obviously um, statewide rent control. So, but there's nothing to register. Anyway, thank you very much. We are going to move on to May. I'm going to ask you to unmute yourself. There you go. Say hello, May. No, I'll try it one more time. Unmute yourself, please. Okay. We are dealing with people having a little bit of a problem here today. Let's go to Nunzio. I'm going to ask you to unmute yourself.
Thanks, Dennis. I appreciate this meeting. I'm going to be quick. I know there is a lot of people on the line here. What is the situation, this LA wildfire hardship situation for people that are claiming to don't pay the rent?
I'm sorry, I didn't understand the question.
The question is, we have a tenant is claiming that he's having a hardship problem because of the LA
Oh,
wildfire. He
okay.
lost his job.
Okay, I'm glad you raised this question. So due to the fire, uh, do tenants in LA City, for example, or even LA County, have some sort of a buy where they don't have to pay the rent and that the landlords now have to shoulder the financial responsibility because there was a fire? And the answer is no. No municipality has started that. The only thing Los Angeles did just recently is that you can't evict the tenant who brought in a pet or a stranger who was brought into your unit as a result of the fire. That you can't bring forth an eviction. If the stranger came in, but it had nothing to do with the fire, you certainly can evict them. But I'm sure they're all going to make up these stories as to why they had to move into your tenant's apartment. But as to not paying the rent, they don't pay the rent. You serve a 3-day notice, my friend.
All right. Thanks, Dennis. Appreciate.
Moving on to Jesse. I'm going to ask you to unmute yourself.
Hi, actually, my name's Tara, but I let my son use the computer. Anyway, my question is, I have a house in San Fernando Valley in Los Angeles, and I rent out the master bedroom. And my tenant's been there about a year and a half. I She originally it was Airbnb, and then she wanted to stay. So I actually never got a rental agreement. And recently I asked her to sign the rental agreement and she refused because she knows that I'm interested in having her move out. Um, and so that was one thing. And then the other
Okay,
thing,
well, one thing at a time, young lady. Let's
okay,
let's
sure.
talk about that, because how much can my memory hold? One question at a time.
Okay,
So, number one, with regard, this is a single family home, correct?
correct,
Only
yes.
one house on the lot.
Oh, I have a guest house in the back, but
Is it a
she's renting.
legal guest house?
Well, it was built in the 60s as a pool house.
Okay, so
And
it's not a legal house. So you don't have that rented separately, do you?
yeah, I do.
Hmm. Um, Yeah, you have a issue. Well, actually, probably not even. Since this woman's a boarder in your house, she has use of the kitchen and the living room, etc.
No, she has her own private entrance and we turned it into a studio. So she has her own bathroom
Got
and
it. And
yeah.
also, when she's in her unit, is there a wall between her unit and your unit, or is it just a door that's locked?
Well, there's a door, but then we put a wall up
Okay.
against it.
So you have an illegal unit. You have two illegal units, and in both cases, the tenants under LA City rules have no obligation to pay rent, and you've got to pay them thousands and thousands of dollars to move because you've created two illegal units.
Hmm.
So I would tread lightly in this situation. You might even want to offer her some money to move, but you want to get that wall out of the way, at least if it was a door as opposed to a wall that's locked, then you would be in compliance, at least with regard to that unit. But
Well, I
if
can
there's a
move that
wall,
easy.
that's an illegal unit. You've created a duplex in that house, and that's not legal without permit. And also that the pool house in the back that you converted by putting in an illegal kitchen, which you did, and a bathroom, that unit is also illegal. It's not to be rented out separately. So you got some issues.
Yeah, I'm not sure when that was because that came already like that when we bought the property. But okay, so it's easy to just move. It's like a slab that I can move so that the door will be there. So okay, so that's my first question. And my second question is, so she moved her son in there in December, and I told her that he could stay for 2 months, but then I would need to raise the rent to accommodate the extra person. And then she threatened she goes, well, you'll just have to evict me. So,
Right, but don't forget, it's an illegal unit. She has no obligation to pay rent. And you would have an obligation to file an application process with the city, get that approved because it's an illegal unit, and then pay this woman thousands of dollars to get off your property. And then you'd have to serve her with a 60-day notice to vacate. So it's not a pretty sight based on what you've done. So I would try my best to make nice with her and to somehow cajole her to move. Anyway, thank you very much. We are moving on to a phone number that ends 8071. If that's you, I'm going to ask you to unmute yourself. And if you're on a phone, it would be *6 to unmute yourself. Okay. We are going to move on then to iPhone. Ask you to unmute yourself.
Hello, Dennis. This is Chris. I have a question. I got a letter from the city of Huntington Park about having to register a unit as a rental, even though I own it, but my dad lives there and he hasn't paid rent. Well, never. So I was just wondering if that's something that has to be done.
The cancer keeps growing. More municipalities are instituting rent control and ridiculous regulations. Highland Park is the last one to do so. You do need to register your unit if you have a tenant. You don't have a tenant, so you have no obligation to register that unit.
Okay, because I went on their website and the options, they have a scroll down menu, like 5 different options, and none of them said they all wanted me to register the unit. They would not let me claim an exemption from that. So I was thinking of going into the city hall on Tuesday and
I would
talking
definitely go in that because that is just for tenants. So that would mean you'd have to register your own house that you're living in.
Well, I don't live there. That's the thing. My
No,
dad
but
lives.
even if you did live there, you'd have, based on what you're telling me, you'd have to register your own house.
Yeah, okay, yeah, that makes sense. So yeah, they found me through the tax rolls a bit, I guess. I don't know if it's through the assessor data or have you that shows that I own a different property and I'm not claiming that on my taxes as a homeowner exemption. So
Yeah.
they're just coming out of the woodwork with
Well, and let me ask you this. Is it possible that a person on this planet Earth can have two houses? Isn't that
people.
possible?
Yeah,
That
people
and
don't really
I
want
want
that, I
two
guess.
houses, some days I want to live in the valley, some days I want to live in the city. I mean, come on, this is insane, but that's what we deal with. Thank you very much. We are moving on to Fred Morris. I'm going to ask you to unmute yourself.
Yes, hello, Dennis.
Hello,
How are you?
Fred.
Hey, quick question. So, a property that I own in Compton, um, no rent control. So, the tenant, she was going through a hard time. Her boyfriend went to jail. Anyways, long story short, she was due on January to be 8.9% CPI plus 5%. To help her out, I gave her only half of that rent increase. Am I able, in a couple months, since her situation got a lot better now, I give her the remaining of that 8.9%?
And the answer is yes. You can do it twice within any 1 year period.
Right, that twice within a 1 year period. Okay, second question, sir. For properties in LA, rent control, or even the ones that doesn't have rent control, have both. If I'm building an ADU, but the tenant is giving me a hard time, like they don't want to clean up their storage area, which is they're using the garage as a storage. So I have 7 units in LA. 6 of them don't have it in the lease, so they're cooperated. They're moving their stuff out, so I can pay the structural engineer for to obtain the permits. I have one guy that has it in his contract that he actually has entitled to an actual garage, because I have carports that I had to move all the stuff
Right,
in.
but is this in the city of Los Angeles?
In Los Angeles, correct? Yeah.
Okay, so this is very simple. Serve the tenant with a 30-day notice that you're removing his right to use that garage, and you have to give him a corresponding decrease in rent. It's there's a chart, anywhere from $70 to $220, depending on how much off-street parking there is. You're telling me really, though, he's not using it for his vehicle, he's just using it for storage, correct?
Correct, because I have carports for the parking.
All right, so then it would go under the taking away of storage. How much is that? And there is a chart. You can call me at the office. I can send that out to you. And then so your rent will be decreased, let's pretend by $50, and you got to get your stuff out of there in 30 days. And if it's not out in 30 days, you have the right to move it yourself.
30 days. But am I able to like pay the structural engineer for the permits? I just don't want to lose my money. So would I have
of
to wait?
course. Yeah, you can pay, do it. You're going to get rid of, he has to get his stuff out of that storage area within 30 days. But again, you also have to give him a corresponding decrease in his rent.
$100 you think would be sufficient?
I think it'd be more than sufficient for storage.
Okay. Thank you, sir. Appreciate it.
All right. Good question. My good friend Harold, how are you?
I'm delighted to be here with you, Dennis. Always. It's like from now on to the end of time, unless you pass on, we've got this university to just keep us informed. Here's a question I have about single family owner occupied bathroom issue. Is it mandatory for me to have an air ventilation system in that bathroom, or is the window with an air vent good enough?
I'm certainly not a contractor, so I don't know building regulations, but the place was built to code, so if it didn't have a vac system there to remove, the air, just a window, that would certainly seem okay by me.
Okay, that's good. And
okay, oops. I'll unmute you again, Harold. Did you have something else you were asking? Please unmute yourself.
I just wanted to get your opinion on the Lakers now that they got new players.
I think it's great. Even though we lost our last game, Luka, I think, will be a great addition to the Lakers. And I'm predicting a championship, and this will be recorded. All right. Thank you very much. Moving on to Your Majesty. How are you?
How you doing, sir?
I'm good.
Yeah, I have just a question. I had a Section 8 tenant who had her boyfriend staying with her, and he wasn't on the lease. She tried to add him on to the her Section 8 contract, and so they sent me a paper asking me would I accept these two people on the lease. I mean, on the contract. They told me I had a right to deny it, and they would just give her reissue her a voucher. So I didn't want to okay the guy that was staying there illegally already. So I said no. So now I get a paper from Civil Rights Department, and one of the people on the paper was an infant, but it didn't state infant, it didn't state age or a relationship or anything. It just had two new names for me to add. So they're saying I discriminated against her because I did not allow the infant.
But you were never told about an infant. You're only told about an adult male, correct?
Correct. The infant I learned that the infant is 8 months old and been staying there for 8 months.
Right, but who is it? Her infant?
Yes.
Okay.
It's her
well,
infant.
obviously, I think you should have an attorney get involved in this at this point, but at the very minimum, write a letter back saying, I have no problem with the infant there. I just have a problem with the adult male.
Well, they're gone now.
Oh, okay. Well, then you need to have an attorney look at this. My firm can easily handle this for you, but you should have an attorney, because what they're going to do is they're going to possibly file a lawsuit based on discrimination. So
okay, so I can get in touch with you through number?
Just call our number 1-800-77-EVICT. That's EVICT, And we are closed on Monday for President's Day, but we will reopen on Tuesday.
Okay.
Anyway, thank you very much. We are going to end with Hortensia. How are you? Say hello.
Hello, good afternoon. Can you hear
Hi.
me?
Perfectly.
Oh, okay, I'm sorry, I was listening. I have a question. If I have a city of LA RSO property, a fourplex, and I'm building an ADU on the back, once I finish with the ADU, that will be automatically under RSO, correct?
No, if the ADU is not attached to the main structure, then it will be exempt because its certificate of occupancy was after October of 1978. So based on that, that will fall under what they call the just cause ordinance for the city of Los Angeles, but will not be under rent control. And you'll be able to, for the initial tenancy, charge whatever you like. And thereafter, you'd be able to raise the rent to whatever level you'd like after that.
And forever or only after 15
No,
years?
well, for 15 years, then it will, assuming the law is still around, it'll fall under statewide rent control. Anyway, thank you very much. I want to thank everybody for coming out. You know, we're going to be doing this next week on Saturday at 3 p.m. If you are in the YouTube room, I would please ask that you subscribe to my channel. It really does help me. And with that, ladies and gentlemen, I want you to have a wonderful Valentine's weekend and a happy President's Day, and we'll see you next week.